He spent his entire career studying the law. Then he used that knowledge against an 83-year-old woman. For years, Daniel Marsh never left his mother's side. His sister, Sandra, was almost nowhere to be found. But in Evelyn Marsh's final months, Sandra and her retired attorney husband, Paul Garrett, suddenly became the perfect family. A brand new will appeared. Daniel inherited nothing, and a $4.3 million estate changed hands through documents that looked completely legal. Everyone thought the paperwork was flawless until the courtroom uncovered the one thing Paul never expected. Knowing the law isn't always enough to outrun the truth. Stay with us until the very end, because today's story proves that the most dangerous inheritance fraud isn't committed by people who break the law. It's committed by those who know exactly how to hide behind it. Evelyn Marsh was 83 years old and had spent her life in Phoenix, Arizona, where she had worked as a commercial real estate agent for 30 years before retiring in 2005. She had built an estate valued at $4.3 million over a lifetime of disciplined work and careful investment, including her home, 3 rental properties across the Phoenix metro area, and an investment portfolio that had grown steadily through decades of patient management. Her husband had passed in 2014, and her son, Daniel, 49, had become her primary family support almost immediately afterward, adjusting his own schedule around her needs and maintaining the kind of daily presence that had made him the person she called first whenever anything required attention. Her daughter Sandra, 55, had lived in Scottsdale for over a decade and had maintained what could most accurately be described as a polite distance from the family's daily life. She visited at major holidays, called with reasonable regularity, and had never played any meaningful role in her mother's care or practical affairs. Daniel had long since accepted this as simply the shape of their family and had not spent significant energy resenting it. Sandra's husband, Paul Garrett, 58, had practiced estate law in Arizona for 26 years before retiring in 2019. He had been a competent and respected attorney during his career, known among colleagues for his precision with documentation and his thorough understanding of the specific procedural requirements that distinguished a valid will from a contestable one. He had retired comfortably and had spent the years since traveling with Sandra and managing their own investments. What Paul had never fully set aside was the habit of assessment that 30 years of estate practice had built into his professional instincts. He understood precisely what an estate of Evelyn's size and structure represented. He also understood, with the specific clarity that comes from decades of watching contested estates move through probate court, exactly what conditions made a will difficult to challenge successfully. Evelyn was diagnosed with early-stage dementia in early 2022. Daniel managed the diagnosis with the same steady attentiveness he had brought to everything else. He coordinated with her physicians, adjusted her daily routine, and ensured her care remained consistent and appropriate. He informed Sandra of the diagnosis by phone. Sandra expressed concern and said she would visit soon. She did not visit for 4 months. When Sandra and Paul did arrive in Phoenix in the summer of 2022, something about the visit felt different to Daniel from the first day. They stayed longer than usual. Paul accompanied Evelyn to one of her medical appointments, explaining that he wanted to understand her condition so the family could be appropriately supportive. Sandra spent extended time alone with Evelyn in the evenings, something she had rarely done during previous visits. Paul asked Daniel detailed questions about the rental properties and the investment accounts that Daniel had not been asked before. Daniel noticed all of it and could not identify a specific objection that felt fair to raise. His mother seemed pleased to have Sandra present. Paul was courteous and asked questions that could have been motivated by genuine concern. Daniel told himself he was being suspicious in a way that was unfair to family members who were simply showing up more than they had before. Paul had spent the weeks before the visit preparing. He had researched Evelyn's dementia diagnosis through Sandra's account of the physician's notes, which Sandra had obtained during a phone call with Evelyn's doctor by identifying herself as family.
He had reviewed Arizona's legal standards for testamentary capacity, which required only that a person understand the nature of making a will, the extent of their property, and the natural objects of their bounty at the time of signing. He understood that early-stage dementia did not automatically preclude testamentary capacity under Arizona law, and that a document prepared and witnessed correctly with no obvious procedural errors would require substantial evidence to overturn. He prepared the will himself, using his own professional expertise to ensure every procedural requirement was met. The document was formatted correctly, referenced the appropriate statutory provisions, and contained exactly the kind of precise legal language that made it appear entirely legitimate to any initial review. It named Sandra as sole beneficiary of the full estate. Daniel was not mentioned. Evelyn Marsh passed away in November of 2022. Paul filed the will within the week.
Daniel discovered the document when the estate attorney contacted him. He read it twice and then called his own attorney from the parking lot of the estate office, still holding the copy he had been given. His attorney was Margaret Wells, a probate litigator in Phoenix with 19 years of experience and a specific background in cases involving attorneys who had used their professional knowledge in estate matters affecting family members. Margaret had handled 2 previous cases with similar profiles and recognized the document's characteristics immediately. She noted that the will had been prepared with a level of technical precision that was inconsistent with a document prepared by a layperson, but entirely consistent with one prepared by someone with decades of estate practice. She identified Paul's former firm through bar records and obtained his professional history, which confirmed his 26 years of estate law practice in Arizona. Margaret retained a forensic neuropsychologist who reviewed Evelyn's complete medical records from the 6 months surrounding the signing and provided an expert assessment of Evelyn's cognitive state during that period. The assessment was nuanced and careful. The expert did not conclude that Evelyn had been entirely without capacity. She concluded that Evelyn's capacity had been variable and context-dependent, that her ability to understand complex legal documents had been specifically compromised in ways that the standard testamentary capacity test was not designed to capture, and that the circumstances of the signing, including the specific morning timing selected by Paul, the preparation conversations he had conducted with Evelyn in advance, and the absence of any independent attorney representing Evelyn's interests, had been structured in a way that maximized the appearance of capacity while minimizing the conditions that would have allowed genuine, informed consent. Margaret also obtained the records of the witnesses Paul had arranged and found that both had professional relationships with Paul that predated the signing and had not been disclosed to the estate or to Daniel at any point. She then retained a legal ethics expert, a former Arizona State Bar Disciplinary Board member, who reviewed the circumstances of Paul's preparation and execution of the will and provided an opinion that Paul's conduct represented a significant departure from the professional obligations that attached to his knowledge as a former estate attorney, even in his capacity as a family member rather than a practicing attorney. The hearing was held before the Honorable Judge Thomas Reed at the Maricopa County Superior Court. Margaret Wells presented the neuropsychological assessment, the witness relationship disclosures, the legal ethics opinion, and a detailed analysis comparing the document's technical characteristics against standard layperson-prepared wills and professionally prepared documents, demonstrating that its precision was inconsistent with anything other than preparation by someone with specialized estate law knowledge. She called the forensic neuropsychologist to testify. The expert explained to the court in careful, accessible language the specific ways in which early-stage dementia affects the kind of understanding required for genuine testamentary capacity, why standard capacity assessments frequently fail to capture those effects, and why the variable nature of Evelyn's cognition made the specific circumstances of the signing, including its timing, preparation, and the absence of independent representation for Evelyn's interests, had been structured in a way that maximized the appearance of capacity while minimizing the conditions that would have allowed genuine, informed consent. She then called the legal ethics expert,
a former Arizona State Bar Disciplinary Board member who testified that Paul's conduct represented a significant departure from the professional obligations that attached to his knowledge as a former estate attorney, even in his capacity as a family member rather than a practicing attorney. Paul's attorney argued the will was technically valid under Arizona law and that Evelyn had demonstrated sufficient capacity at the time of signing. Margaret Wells acknowledged the document's technical precision directly and told the court that its precision was not evidence of legitimacy, but evidence of the specific risk that professional knowledge posed when applied without the ethical constraints that governed its use in practice. She told the court that Paul had spent 26 years learning exactly how to make a document difficult to challenge and had applied that knowledge to the one situation in which his professional obligations most clearly should have prevented him from doing so. Judge Thomas Reed ruled the will invalid, finding that while the document met formal procedural requirements, the totality of the circumstances surrounding its creation, including the preparer's professional expertise, the witness relationships disclosures, the absence of independent representation for Evelyn, and the expert testimony regarding Evelyn's cognitive state, established that the document had been produced through a process that did not reflect Evelyn's genuine, independent, and informed testamentary intent. He ordered the estate distributed to Daniel and Sandra equally under Evelyn's previous will. He also issued a formal referral to the Arizona State Bar recommending review of whether Paul's conduct, though undertaken after his retirement from practice, implicated the ongoing professional obligations that attached to his bar membership. Paul Garrett was subsequently charged by the Maricopa County District Attorney for elder financial exploitation and fraud. He was convicted and sentenced to 5 years in Arizona State Prison. The Arizona State Bar opened disciplinary proceedings that resulted in the revocation of his law license, which he had retained in inactive status since his retirement. Sandra Marsh did not face criminal charges, given the court's finding that Paul had been the primary architect of the scheme. She and Daniel did not speak during the proceedings and have not spoken since. Daniel Marsh managed his mother's estate settlement over the following year. He kept the rental properties under management and used a portion of the estate to establish a small fund at a Phoenix elder law organization that provided independent legal representation to elderly individuals whose family circumstances created conflicts of interest in estate planning. He said his mother had spent 30 years helping people buy and sell the most important asset of their lives. He said the least he could do was make sure someone else's mother had an attorney in the room who was actually on her side. Evelyn Marsh had spent her life working with contracts and legal documents in an industry where precision and integrity were the foundation of every transaction. In the end, the most precisely prepared document in her estate was also the least honest one. The court saw through the precision to what was underneath it, and the knowledge that Paul Garrett had spent 26 years accumulating became in the end the evidence that made his conduct impossible to defend. Would you have known how to challenge a will prepared by a former estate attorney? Tell us in the comments below. And if this story stayed with you, subscribe to Court of Shadows for more courtroom drama stories every week.